Good afternoon. This is Chavez and Valko, the key to your immigration services. My name is Ben Hamilton. I'm a senior associate attorney here. With me today is Andrew Craven, one of our associate attorneys. And together we practice employment-based immigration law. And today we are going to talk about the L-1A intracompany transfer. So Andrew, how you doing?
Doing good. How are you, Ben?
I'm doing all right. If you're watching this, 4th of July just passed, so there was lots of fireworks and good times to be had. Andrew, how do you feel about the L1?
It's definitely a convenient route for the folks that it does apply to. You don't have to deal with the cap like you do with the H-1Bs, and it's a little broader than the TNs that only affects Canadians and Mexican citizens.
So it does definitely have some
one.
pros. Has some pros, definitely has some cons. Mostly if you're like me and you've been around a while, you've noticed how USCIS has just become increasingly more difficult and more demanding. But let's jump into it. Today we're going to talk about the L-1A. There is an L-1B, but we're going to leave that for another day because it's kind of its own complicated mess to talk about. And this is obviously part of our series where we're trying to do a discussion and create a video about every single visa type. We're going to get there eventually. So, Andrew, to start, what is the L1 visa?
So the L1 visa allows multinational companies to transfer certain employees to the U.S.
Okay, so you said certain employees. So define that. Which employees?
So very specifically, the L-1A applies to managers or executives versus the L-1B that applies to employees that have specialized knowledge.
So in general, can I use the L-1A to transfer my janitor?
No, it's got to be someone who's up at the top. So either your managers, and we'll get into specifically which managers, or your executives.
Well, like I said, today we're going to focus on the L-1A. So we're going to leave the L-1B specialized knowledge aside, focus on the L-1A. So give me the definition. What is an intracompany transferee?
So this means someone who, within the last 3 years, preceding the time of his or her application for admission into the U.S., has been employed abroad continuously for 1 year by a firm or corporation or other legal entity, parent, branch, affiliate, so on, who seeks to enter the U.S. temporarily in order to render his or her services to a branch of the same employer or parent, affiliate, so on, in a capacity that is managerial, executive, or involves the specialized knowledge.
That is a really long run-on sentence there, as written by our esteemed government. So let's break this down into its individual components. So the first one is 1 year within the last 3. So it says employed abroad continuously for 1 year within the last 3. So what do they mean by abroad?
Basically, just abroad. So anything where he was physically employed outside the U.S. for 1 year within the last 3. Abroad applies to anywhere physically outside the U.S., so it doesn't have to be that individual's home country, just anywhere not the U.S.
So if I'm a Mexican national, but I've been working in England, that applies.
Yes.
Okay, well, it says employed abroad continuously for 1 year within the last 3. So what do they mean by continuous?
So continuous means without any significant breaks during that qualifying year of employment. So for instance, entering the U.S. briefly as a tourist, so going to Disney World for a week, that's not a break in the continuity. But entering, say, as an F1 student for a full semester, that's likely to break that continuous year.
Yeah. And again, we're looking at 1 year in the last 3. So if you've been working somewhere for 3 years and there was a break in continuity, but it's still, each half still adds up to a year, you're fine. It's for those people that have exactly 1 year of experience, but then something weird happened. Maybe they were working for a different company in the US, or they were a student that all of a sudden you can have this break in continuity. I know we had a client who came in on an M visa to go to flight school. And then we ended up with issues where it was like, oh, wait a second, 1 year in the last 3, I think we only get to 9 or 10 months out of 12 because that M caused issues. That's also obviously our next one is, well, what do they mean by 1 year within the last 3? How does that work?
So basically, the time that person applies, USCIS is going to look back 3 years, and the person must have had a continuous year of qualifying employment within those 3 years.
So what if I worked for someone for a full year, I left them for a full year, and now I'm coming back and they want to transfer me to the US? So I haven't worked for them for a full year.
Right, but you did have that 1 year of qualifying experience. You've been gone for a year, but we're still within 3 years, so that would qualify.
Awesome. Are there any exceptions? So we're talking about 1 in 3 from the time of application. So if I file my application right now, they're going to look back 3 years to see if I have 1 year of continuous employment within those 3. Are there any exceptions to that?
Yeah, so if someone entered the U.S. in another status to work for that same organization, immigration will then look back 3 years from when that person entered and not when they sent the L-1A application.
So let's discuss an example here. If I am working for company A in Mexico, and now company A wants me to come to the U.S. to work for a subsidiary, let's say, company B, and I enter as a TN. And let's say I'm working on that TN in the US for 6 years. So I get 3, I extend it for another 3. I'm here for 6 years. And then all of a sudden they decide, hey, we want to swap you to an L. So at the time I'm applying right now, it's been 6 years since I worked abroad. Is that acceptable? Is that going to pass for an L?
Yes, because it was with the same organization. So they're not going to look at the last 3 calendar years. They're going to look at that 6 years ago when you entered, 3 years before that, did you have that year of qualifying experience?
Yeah, and where we run into issues is that we're the people, they swap companies, where it's like, oh, I came in originally in the US to work for a related company, but then I changed employers and now I'm coming back and it's like, oh, well, but the 1 in 3, there's a break in continuity. So now we're looking at time of application as opposed to time of entry. But this is doable. And we see it a lot with TNs and Es in particular that may come in, to work for the same company for a number of years and then want to swap to the L. So it does work. So there's do we look at from time of application or time of entry, of last entry? How do we typically prove 1 year in the last 3? So what documentation do we submit to USCIS to try and prove that?
The easiest one, the one we prefer, is just a full year of pay stubs showing that you've been working for that company for that full year. You can use other records, though, so HR records that might include, say, the formal offer letter from that HR department that states what the person's going to be doing and all the key details that are needed to show a year of qualifying employment.
Yeah, a good old employment verification letter goes a long way. But yeah, I don't know why, but USCIS loves their pay stubs. But of course, that doesn't always work because sometimes the person we're bringing in on an L is the owner of the company, and they might not necessarily be receiving salary. And then we have to kind of look for some other things. You'd think if they're the owner of the company and their name was on all the incorporation documents that they would just accept it, but they don't. And then they want to ask, dumb questions that we prove the owner of the company has actually been working for it within the 1 year within the last 3. But hey, it happens. So, okay, so 1 year within the last 3, I think it's relatively straightforward. A few little things there. about you do have to be physically abroad. It does have to be continuous. And the one in the last three, whether it's from admission or application, depends on your current status. So the next key area is qualifying organization. Okay, so what is a qualifying organization?
So that means a U.S. or foreign company that is a branch, affiliate, parent, or subsidiary of the other.
So this is where we start getting into all the fun definitions. So what's a branch?
That's an operating division or office of the same organization housed in a different location.
Yeah, so sometimes these are not actually incorporated, or sometimes you can actually seek to get the foreign company sort of authorized in the U.S. So there's not an actual separate legal entity, and that's usually what a branch is. Okay, so what qualifies as a subsidiary?
So that means a legal entity which a parent owns directly or indirectly, and more than half of the entity is controlled by the other entity.
So two key things here. One is more than half. This is why people hear about the 51% rule. It's technically 50 plus a fraction, but yes, it does have to be a majority owner. So 50 plus a fraction, 51% in order to qualify. Which is, some people get confused with the e-visas. Is the e-visas specifically say 50%, whereas the L is 51%. So just that little distinguishing between the two visas. The other thing is it's not only ownership, but it's also control, right? So sometimes you can get a request for evidence where you've submitted everything showing that company A owns company B, but then they want, some further evidence to show that company A controls company B. Like, all of the, executives and managers in company B report to company A, or something to that effect. So what is an affiliate?
So an affiliate is one of two subsidiaries, both of which are owned and controlled by the same parent or individual, or one of the two legal entities is owned and controlled by the same group of individuals, each individual owning and controlling approximately the same share or proportion of each entity.
So in general, there's two ways to qualify as an affiliate, right? You either have the same majority owner. That majority owner can be an individual, or it can be a company, like a parent company or some type of holding company. So if the same company or individual has at least 51% in each company, then they're affiliates. And those are usually the most straightforward ones that we see. The more complicated ones are where there's no majority owner. So let's say you have, 4 brothers, each owning 25%. Okay, that's great, as long as the same 4 brothers own 25% in the U.S. company. It basically has to match, right? So it says the same owners in approximately the same shares. So again, if we have 4 guys in company A, you're going to have the same 4 guys in company B. Now, maybe their share percentages are slightly different between the companies. That's okay, but it's the same shareholders. So we run into issues is where it's like family owned and like, oh yeah, there's 10 members of the family that own the company in in Mexico. But yeah, we cut out grandma and there's only 9 of us in the US company. And you're like, well, you probably shouldn't have cut grandma out because it says the same shareholders in approximately same percentages. So there's leeway on the percentages, but not so much on the shareholders. So again, 2 ways to qualify as an affiliate: same majority owner, or no majority owner, but basically the same shareholders at the same percentages. Are there any exceptions to the qualifying relationship rule?
Yeah, so there's a specific carve out for the big accounting firms that basically says that a partnership that is organized outside the United States to provide accounting services shall be considered an affiliate of the United States partnership if it markets its accounting services under the same internationally recognized name under the agreement with the worldwide coordinating organization of which the United States partnership is also a member.
So it's kind of complicated, but a lot of people, they see names like EY and PwC, KPMG, Deloitte, and these are big international companies with offices all over the world, and they think, well, these got to qualify for the L, right? Well, what they don't realize is as accounting firms, they're all actually individual partnerships. There's no parent company There's no overlap. The partners in the U.S. own the U.S. company, the partners in London own the London company. So in England, so hypothetically, they don't meet the qualification test for the L. But I guess they have very powerful lobbyists. They got their own carve out. So as long as you're marketed under the same banner, the L visa still works for the big accounting firms. Are there any other rules regarding qualifying organization? We've talked about sort of the relationship between the companies, but are there any other qualifications to be considered a qualifying organization?
Yes, to be a qualifying organization, they must be doing business both in the U.S. and abroad. And the way they define doing business is regular, systematic, and continuous provision of goods and or services. And basically, you have to be operating as a business. You can't just have a shell company.
Yeah, also we hear sometimes people are like, I got this great business in Mexico and I'm going to get the L. And then when I get the L, I'm just going to sell it all and put it all into the U.S. business. And you're saying, actually, no, you will no longer qualify for the L if the foreign business ceases to do business. So actually, for as long as you have the L, the foreign entity needs to be continue doing business. Are there any exceptions to the doing business rule?
Yes, if you're setting up a new U.S. office, there's an exception.
So we're going to get to that a little bit later because that's a whole other little thing there talking about new office Ls, which is a thing. Okay, so we talked about the qualifying organization, right? It has to be doing business in multiple countries, right? And the related companies have to have a qualifying relationship. So the next thing is, well, it says you either have to be a manager or an executive. So we'll talk about managers first, right? Okay, this is going to be another one of those mouthful explanations, and then we'll break it down and talk about it a little bit more in detail. But how does immigration define a manager?
So there's 4 criteria. Number 1 is they have to manage it, the organization or a department, subdivision, function, or component of that organization. Number 2 is they have to supervise and control the work of other supervisory, professional, or managerial employees, or manage an essential function within the organization or department, subdivision, organization. Third criteria is they have to have authority to hire and fire or recommend those, as well as other personal actions of another employee or other employees are directly supervised. If no other employee is directly supervised, then they have to function at a senior level within the organizational hierarchy or with respect to the function managed. And finally, number 4, they have to exercise discretion over the day-to-day operations of the activity or function for which the employee has authority.
Whew, okay, I almost fell asleep during that. But it's actually super important because this right here is the biggest headache when it comes to the L-1A by far. Are you a manager? So many people say, well, I'm a manager. My title says manager. Well, USCIS does not care about titles, right? They have this very specific definition of which they've somehow used to just browbeat people into submission. So 3 of the 4, I think, are fairly straightforward, right? You have to manage the company itself or a major, department, function, subdivision. Okay. You have to have some HR authority over the people whom you're supervising. It can be hiring and firing, but sometimes it can be just like leave and stuff like that. And you also have to have a certain amount of discretion to be able to manage, what it is you're managing. But one of the ones that always catches people up is number 2, because it says supervises and controls the work of other supervisory, professional, or managerial employees. So, question, does the supervision of line employees count? As an example, like a factory, all the factory workers on the line, or maybe like I'm a manager at a McDonald's or something. Does that type of supervision count?
No, so the employees must be either professionals or supervisors themselves. So it can't be just like I'm in charge of all the janitors or I'm in charge of all the line workers. You have to be in charge of the people that are supervising the line workers. So say manager over the entire factory, overseeing several managers that oversee the line employees.
The way we look at it as there's a two-tiered structure that qualifies. Two-tiered structure is I supervise the employees directly, but those employees are professionals. So like, I don't know, I'm the accounting manager. I have 6 or 7 accountants that report to me. They're all professionals with degrees in accounting. Two-tiered structure, fairly small structure, that can qualify. The alternative is a 3-tiered structure. So let's say I work in a factory and there's a bunch of factory line workers. I don't supervise them directly, right? Above them is our supervisors or managers, and I supervise them. I supervise the supervisor managers who supervise the employees. So that's a 3-tiered structure. So it's going to require more people. So we have a guy that like owned, a small pizza franchise, like a Little Caesars franchise, right? Has 5 or 6 employees. If you'd had just one, he never would have qualified for the L. But in this case, he bought 3, right? Each had like a store manager, and then he hired a general manager. And so, of course, in this case, he's saying, well, I supervise the general manager and kind of like the store managers. I don't supervise the actual employees, of which there's like 5 or 6 per location. So it gets really kind of nitty gritty. And these days, man, when it comes to requests for evidence, USCIS is just digging deeper. I mean, to the point where they want full blown, or they will not only want full org charts, but they want job descriptions for all of the subordinates. And they want to know their job title, description, pay, education level. And they want you to back all that up too. So you got to get all the pay records for the subordinates, degrees, resumes. I mean, it's insane the amount of detail that USCIS requesting these days. But if you were listening closely to Andrew's description, you would have heard some key language in there, right? So here's the question. So what if I occupy what is considered a clear managerial position, but I don't have any direct reports? So let's say, for example, I'm the HR manager for an organization, or maybe I'm like the CFO. Yeah, maybe I have like one, secretary or something. There's no way for me to qualify for the L, or can I?
So USCIS does allow for what's called functional managers. So they must manage a clearly defined and essential function in the organization, and they must function at a senior level within the organization and exercise discretion over that function. So for your example, the chief financial officer, they're clearly at the top of the company, clearly managing a higher function of the entire organization. Even if no one directly reports to them, they're still what would be called a functional manager.
Yeah, so if we look at the definition, right, those 4 points, the first one is manages a function of the organization, right? The second one says the same thing. The third one says, has the authority to hire or fire, or functions at a senior level. So there's that or in there, functions at a senior level. And then, of course, 4 exercises discretion. So you can see that functional managers is actually something that does exist within the law. It kind of exists within the regulations, but then through case law and lawsuits, they've kind of pulled it out and sort of further defined it and cemented it as existing. And some of the key points are, even though you manage a function and you have no direct reports, you still have to show that there are people that relieve you from performing non-qualifying duties. So again, if we're talking about the CFO, yes, he manages a major function of the company, operates at a high level within the organization, but we also don't want to show that like he's entering, accounts into the ledger himself. In this case, they've probably hired a third-party like accounting firm that's handling a lot of the budgeting. They may have a low-level person within the company who's doing it, but you want to show that they're relieved from performing non-qualifying duties by other people within the organization itself, or it can be sometimes third parties. Again, if you're looking at like sometimes you get like a sales manager and they're hiring independent salesmen, they're hiring independent people handling their marketing and advertising. So there are all of these like third parties that are really doing the kind of day-to-day, and this person's just kind of managing the overall department. So a functional manager is a very real thing that we use quite often. Again, HR manager, CFO, business development manager is another one we see a lot, right? As opposed to like operations manager. Operations managers usually where all the employees are, and those ones are straightforward and easy, kind of what USCIS expects to see. But we do a lot of the more nuanced ones. Okay, so you can be a manager or an executive. So how does USCIS define an executive?
So an executive also has 4 criteria. So they have to direct the management of the organization or a major component or function in the organization. 2, they have to establish the goals and policies of the organization, component, or function. 3, they have to exercise a wide latitude in discretionary decision making. And finally, 4, they can receive only general supervision or direction from a higher level executive, like the board of directors, stakeholders of the organization.
So it's just higher level. The manager is down there managing the day-to-day, but they're not necessarily establishing goals and policies or, and they're reporting to somebody, right? Whereas you're looking at an executive is a level above that, right? Where they're really not reporting to anybody, maybe the CEO, maybe a board of directors, but that's it, right? They're setting goals and policies, very, very top. That one's a little bit more straightforward. So in general, how do we document or how do we prove that they qualify as a manager or executive?
So typically we would start with a detailed organizational chart and job description, and then just kind of go from there as to what documentation really fits with their particular organization and particular position.
Yeah, I mean, again, we're coming back to they want very detailed job descriptions. Like not only just like the general job description, like you could pull off the Department of Labor website, but they want to know the daily job description. Like what is it that you do on a daily basis? You can assign percentages of time to sort of each thing you do. Obviously, they want to substantiate the employees that are being supervised. So they want to see payroll records. Like in the US, you'd have W-2s, 941s, 1099s, org charts, employee lists, all the information to back up that those employees are professionals or are supervisors or managers. Like it can be extremely intense. So couple questions here about the individual who's actually applying, right? So we talked a lot about sort of kind of the company qualifications in terms of qualifying relationship, doing business. You have to show that the position is going to qualify. About the beneficiary. So if you're the actual individual who's applying for the L visa, and other than showing that you've worked for 1 year in the last 3 in a position that's managerial, was there anything else that you have to prove?
Yeah, so we would prove up the person's prior education, training, employment, all that must qualify him or her to perform the intended services in the United States. However, the work in the United States does not have to be the same work which was performed abroad.
Yeah, so they're well within their rights to basically say, well, does the person have the education or experience to even perform this job, and to ask for that type of evidence? So obviously degrees, any types of certifications, licenses, permits are you're going to have to include. So a lot of visas require what's called non-immigrant intent. You have to sort of prove that you're going to return to your home country. Does the L-1A require non-immigrant intent?
No, like the H-1B, the L-1 is a dual intent category.
Are there any other special considerations regarding the actual beneficiary or the person who's applying?
Yes. So if the beneficiary is a owner or major stakeholder of the company, the petition must also be accompanied by evidence that the beneficiary's services are to be used for a temporary period, and evidence that that beneficiary will be transferred to an assignment abroad upon completion of the temporary services in the United States.
So it's this kind of weird thing where it's like you don't have to show immigrant intent, but if you're the owner, you have to show that you're going to return. I don't know why that's there. It is stupid. Like, why am I the owner being held to a different standard than my employee? But whatever. We get a letter from the company saying, hey, while I'm gone, so-and-so is going to be in kind of charge in a company back home. And we plan to be here for, 3 years and then return, right? You get a letter, but at the end of the day, if the individual, decides they want to stay and apply for residency, they're going to stay and apply for residency, right? So it seems kind of like a waste. It pops up, they want that letter, but I've never seen someone actually like get denied or get any real grievance about it. And again, this only applies to people who are like a majority shareholder in the company. Now we're going to get back to the fun stuff. We talked about how a new office now again, this only applies to the U.S. company, not the foreign company, but it is possible to apply to set up an office. So what is considered a new office?
So a new office means an organization which has been doing business in the United States through a parent, branch, affiliate, or subsidiary for less than 1 year.
Yeah, so if the company's been operating less than a year, you can apply as a new office. So what are the basic qualifications you have to prove in order to get a new office?
So 3 qualifications. 1, sufficient physical premises to house the new office have to be secured. The beneficiary has to be employed for 1 continuous year in a 3-year period preceding the filing of the petition in an executive managerial capacity, that the proposed employment involved executive managerial authority over the new operation. And then finally, number 3, the intended United States operation within 1 year of the approval of the petition will support the executive or managerial position.
Ooh, so ironically, you have to have a lease agreement. That is like mandatory for a new office L. In general, what we say is, well, first off, you have to like set up the company, incorporate it, so you can prove who the owners are and that it's related. Ideally, you want to open up a bank account, maybe move some money so you can show that you're serious. You have to get a lease. And then you need like a 5-year business plan, which is the next thing I'm going to get into, right? Because you said the third one is you have to show that the U.S. operations within 1 year of approval will support an executive or managerial position, right? So are there specific things that go into that?
Yes. So immigration requires information on the following. So they need the proposed nature of the office, describing the scope of the entity, its organizational structure, and financial goals. Number 2, the size of the United States investment and the financial ability of the foreign entity to remunerate the beneficiary and commence doing business in the United States. Then finally, number 3, the organizational structure of the foreign entity.
So a lot of that really just goes into a business plan. Say, hey, we think to start this company, it's going to be $500,000. And look, hey, we have $500,000. And then, here's our plan to set it up and whatnot. Getting the new office L isn't terribly difficult, right? Because it's all based on what's going to happen within a year. They just have to believe that within a year, you will have done what you said you're going to do, and you will then qualify as a manager. So I apply now, right? They give me a year, and I have to prove that within that year, I'll qualify as a manager. So for the new office Ls, what's difficult is the extension, obviously, because you only have 1 year to get to a point where you now qualify as a manager, meaning there's sufficient whatever's going on there to support you. And that can be difficult in a year. I mean, come on, most companies will say it's like 3 to 5 years before you're really like self-sustaining. So immigration putting this like 1 year requirement can be really difficult for people. If it's a large organization, they have a lot of funds to be able to really push into the project, and great. But if it's a smaller company, you can get the new office L, but then sometimes the extension can be pretty difficult. But hey, look, it's a great option if you have worked for a full year in this company abroad and you're like, well, we don't have anything in the US, but we're looking to set something up. Well, then great. I mean, the new office L, it can be the lowest barrier to entry because the investor visas a lot of times require that you've already made the US investment and the US company be real and operating. So sometimes it can take longer to get to a point where you can apply for like an investor visa, whereas like the new office L can actually get you in the door faster. Because there really doesn't have to be a lot there in place already. So talk a little bit about the L-1A process. So let's say, hey, I've been working for 1 full year abroad in a position that's managerial. So what? I just go apply for the visa? How does this work?
So the first step would be submitting a detailed application to USCIS, and you need USCIS to approve it before you can go apply for the visa at the consulate or embassy.
So this is true of a lot of visa types, right? Actually the majority, that you actually have to first go to USCIS to get approval. So it's H, L, O, R. You go down the list. I mean, the exceptions are like the E visas and like TNs. How long does it take? So if I submit my application to USCIS, how long?
Regular processing, about 4 to 6 months. You can file premium processing for just the small fee of $2,500. And then that'll cut down the processing time to 15 days.
But let's be honest. At the end of that 15 days, am I getting a denial, an approval, or a request for evidence?
Most likely, what a lot of immigration attorneys see is that at the end of that 15 days, they get a request for evidence on the L-1A specifically. And generally, that means that you have, a period of time to answer that RFE, and then that 15 days starts back over.
And to be honest, we feel a lot of the time those requests are bogus. They don't have enough time to actually get to it in 15 days. So rather than refund you your money, they just throw out a request for evidence, and that stops the clock for them. Great. You didn't have to refund the money, but now you just wasted a ton of time and money for us to have to now respond to a largely bogus request. I mean, it kind of depends. But I would say there's a higher degree of bogus requests when you use premium processing than regular processing. So if I'm approved, how long is my approval for?
So for an existing company, the initial approval is 3 years. For the new office, it's 1 year. So you have that 1 year period to get up and running.
Okay, so I can file extensions?
Yes, so you can continue to file extensions for 2-year increments until you've hit 7 years.
So then once I have the USCIS approval, can I now apply for the visa?
Yeah, so you can apply for the visa with any dependent, so wife, family member, and that includes spouses, but then children under 21 can also receive the L2 visa.
So if my family comes in with me and they're L2s, can they work? Can they go to school?
So all the family members can attend school. Spouses are the only ones that can request work authorization after they arrive in the U.S.
So it's important to say that spousal work authorization is not automatic. You have to submit a specific application to USCIS after you enter the United States on that L visa. Quick thing is to say, remember, there's a difference between the approval and the visa. The approval is sort of the document that allows you to get the visa, allows you to get status, and controls how long that status can be. The approval is not a document that allows you to travel. It's not a travel document. That's the visa. So typically, if you're outside of the U.S., you get the USCIS approval, go apply for the visa, and then come in. And then obviously they'll let you stay for as long as that approval. If it's 1 year, 3 years, or 2, if it's on an extension. But another question, what if I'm already here in another status? Can I file the change of status?
In general, yes, but there are certain exceptions. For instance, if you entered on a visa waiver, then you can't file to change status in the U.S.
Yeah, so you have to file with USCIS, leave, get the visa, and come back. So that's the downside to visa waiver, is that they do not allow changes of status. So we said that you have to file with USCIS first. Are there any exceptions to that?
Yes. So for Canadian citizens, they can apply directly with CBP when crossing the border or passing through an airport.
Do we generally recommend that?
No, I mean, I generally would not recommend dealing with CBP when you can work with USCIS.
CBP is probably last on my list of government soup agencies to want to deal with. Gosh, they're terrible. and especially in Canada. I swear they must get like bonuses for how many people they denied. It's awful. And it's done right there on the spot, and there's like no sort of appeals recourse. So depending on the case, I mean, if it's a clear-cut case, I mean, if you got a guy who's like, I work for Microsoft and I'm Canadian, can I just do it at the, well, that's would probably be a blanket L. We'll get to that in just a sec. But if it's like a clear-cut case like that, okay, then fine, right? But otherwise, it's like, let's go to USCIS first, because then once USCIS approved it, you've now taken that decision out of CBP's hands completely. You now have this USCIS approval, so USCIS just stamps you through, right? They can't really give you any grief. And so it kind of depends on the case. Lately, most of our Canadian cases have been a little bit more on the difficult side, like functional managers. So I'm like, let's go to USCIS. Now, even when you do go through CBP, CBP still forwards the case to USCIS. So USCIS still sees it. And I guess they could send out an RFE or even deny you even after you've been entered. But I would, depending on the case, we kind of we decide whether or not we go with USCIS or CBP for Canadian nationals. I mentioned the blanket L. So, hey, I heard my employer has a blanket L. What does that mean?
So an L1 blanket petition is a single petition that can be approved for large multinational companies. And this eliminates the need to file separate L1 petitions for each employee. So you can use a blanket L approval to skip USCIS and apply directly for the L1 visa.
Yeah, the blanket Ls are pretty cool. So obviously you tend to only see them for large companies like Microsoft or Google. But if you can get one, they're awesome, because basically USCIS has said, company, you are so big, we're no longer going to question whether or not you're a qualifying organization, whether or not you're doing business or any of that, right? We're going to skip all of that, and all we're going to look at is the individual employee, right, and whether or not they qualify. So as part of it, you get to skip USCIS completely. So if your company has a blanket L, you can just go schedule the appointment, go right into the interview. You obviously have a copy of the blanket approval and the evidence that you've been a manager for a year. There's also a specific form you have to take with you. It's called the I-129S. You take in with you, and then they stamp it, approve it, give you the visa, bam, you come in. So you get to skip the whole USCIS component. What are the requirements for a company to get a blanket L?
So first, they must have an office and have been doing business in the U.S. for at least 1 year. Two, they must have 3 or more domestic or foreign branches, subsidiaries, or affiliates, and be engaged in commercial trade or services. And then finally, they must have U.S. sales of 25 million, a U.S. workforce of 1,000, or have received approval of at least 10 individual L petitions in the previous 12 months.
So obviously they're looking at, you have to have been doing business for at least a year. You have to be doing business with multiple companies or in multiple locations. It's not just like I have one place in Mexico and one place in the US and that's it, right? That's not sufficient. And then of course they're going to look at either your sales, total workforce, or if you've done previous L petitions. Okay, let's see if we can stump Andrew here. If I file a blanket L on behalf of a company, they essentially get them certified and approved for the blanket L. How long is the initial approval for?
The initial approval, I want to say, is 1 year.
It's 3 years.
3. Okay.
Gotcha. Now, if I file an extension, if I file a renewal of my blanket L, how long is it good for?
Then it's good for 1 year, right?
No, it's good indefinitely. Right. So if you're a company and you're applying for your very first time for a blanket L, they'll give you a 3-year approval, and then you have to renew it. And if it's successfully renewed, it's actually renewed indefinitely. There's no expiration date unless you don't send anybody. But if you're sending at least one person a year, every single year under that blanket L, or a couple of people, that blanket L remains valid indefinitely. So let's say someone like a Microsoft, they're not ever renewing that blanket L. They got the initial, renewed it, and then they've just had it ever since. I mean, it may have been 1988 when they last did it, and it's been good ever since, because I'm sure they're moving people around regularly under the blanket L. So if your company does have a blanket L set up, it's a great option. You get to skip the whole headache of USCIS, just apply directly for the visa and come in. So it sounds not too difficult. I mean, you have to show that the company's that they have a qualifying relationship, they've been doing business, that you were a manager for at least 1 year in the last 3 abroad. You're going to be a manager or executive here. But to be honest, it is one of the most sort of documentation intensive things we do. Some of these things can be 2 reams of paper worth of documentation, and then USCIS will sometimes request even more info. But it is a great option, especially for people that don't have access to certain visas, like that don't have access to investor visas. So an example would be people from Venezuela, India, China, I don't know, Peru, Brazil, anyone with whom we don't have an investor visa. The L is a great option. It's a great option for people looking to open new offices. And it's also a great option because there is a residency category that is very similar. So not all of our visas have corresponding residency categories. So there's some visas like, great, got you the visa, but for residency, I don't know what we're going to do for you. We'll work it out. But there's others that have pretty much a directly corresponding residency category. So if we're able to get you that L, there's a high probability that there's a residency option for you in the near future if that's what you want to do. So, Andrew, any final comments about the L-1A?
No, I think we pretty much covered everything.
Well, if you have any questions, let us know. You can obviously go to our website, and through our website, you can schedule a consultation, right, to talk with someone about your visa options. We are a full-service immigration law firm, so it can be employment-based, it can be deportation, litigation, anything. We handle it. Someone here can help you answer your questions. We also have a great app called Lawpilot GUARDIAN that you can download for free, and there are a lot of neat features in there, especially a whole section on know your rights, which can be very useful if you run into ICE or someone like that when you're at your job or airport or at your house or in your car. Thank you for watching our video. We're probably going to try to do an L-1B next, but until then, thank you very much, and we'll see you next time.